Welcome, and we appreciate you joining us today. I think you have a great presentation by our guest host, Peter, and I'll introduce him in a minute. Just a couple of notes about SCORE, if you're not familiar with our SCORE organization. We're a national organization, a resource partner of the Small Business Administration, and our goal is to help small businesses get started, grow, and prosper. So there are SCORE chapters all across the US, and we have over 10,000 mentors. So you shouldn't have trouble finding a mentor or someone who has the skill set that you might be looking for in your business. The main things that SCORE does, and our services are either for free or for a very nominal amount. We offer webinars and seminars like the one this morning. Ours are for free. Some chapters charge just a small amount, maybe $10 or so. And we offer those in our chapter on a monthly basis. Our national organization offers a lot of webinars with really high-level speakers. And you could go to our website at score.org. Legal issues for small businesses. I want to welcome Peter Greenbaum. He's an attorney with Willens, Goldman, and Spitzer in Woodbridge. There's his email address, and he'd be happy to entertain questions and so forth if you wanted to contact him. Webinar within the next day or so, you'll be getting an email, and we'll include those slides in that email follow-up. And we're also recording the webinar this morning. So the webinar will be, the presentation itself will be up on our webinar at centraljersey.score.org. So Peter has done several workshops for us, and he always gets really high marks from our attendees. So Peter, after the webinar, within the next day or so, you'll be getting an email, and we'll include those slides in that email follow-up. Slides with you. Thank you for working with us again, for providing services to our SCORE clients, and take it away.
Jane, thank you very much for introducing me and for attended over the years. It's been, I get a lot of good questions and a lot of good interactions, which means, folks have questions and I can help them, and I really enjoy that. What I'm talking about today is the legal aspects of operating a business. This is going to be sort of an introductory, intro to, corporate law and businesses. I've done a few of these over the years on behalf of SCORE, and I've always found them to be very enjoyable. And as Jane said, I think it's been great for the folks who have questions, and I can help them, and I really enjoy that. What I'm talking about today is the legal aspects of operating a business. This is going to be sort of an introductory, intro to corporate law and businesses. I'll go through the agenda in a moment. If anyone has any questions, what I've done historically in the old days when we were in person, and I welcomed folks raising their hand and interrupting and asking questions, and I thought that was great because a lot of times the questions were directly on point to what we were talking about, and it opened a sort of a separate dialogue. We'll try it here, as Jane said, ask questions as we go along in the Q&A bar. She'll interrupt, and hopefully this works. First thing I'd like to say is, what's our agenda today? So what I'll be talking about is, number one, the types of businesses or entities, so to speak, that you can operate a business through. Number two is some basic governing documents. What type of basic documents you should have in terms of the corporate side. The third thing is an overview of typical business contracts, meaning not the organizational internal documents, but rather what are types of documents that I typically deal with on the outside. And the two I have listed are employment agreements and office leases, because they come up virtually on all my clients. And then lastly is intellectual property considerations. So hopefully we can get through all of this. And I'll go through some on a very high level and some more detailed. And really quickly before I get into it, sort of on a background side of things, as Jane mentioned, I'm what's called a corporate attorney. I'm a partner with Wilentz, Goldman and Spitzer. We're one of the larger law firms in the state. We have offices, the main office is in Woodbridge is where I'm at. And then we've got offices at the Shore, on Wall Street, and in Philly. We've got about 100 attorneys. Everybody specializes in something. So I specialize in corporate law, and what we call transactional, M&A, which is mergers and acquisitions, and sort of general corporate law. With that sort of intro, and one other thing I wanted to mention, to the extent after we hang up, if anyone has questions, my email is on the slides, which Jane said she'll share with everybody. So if you have questions after the presentation is done, certainly feel free to email me. And also my phone number is on there as well, my office number. So feel free to call or email, and I will certainly be glad to answer anything after the fact. So let's start with sort of the basics, which are types of businesses. And what I mean by this is, what is the avenues you can run or operate your business through? And there's basically 5 types of business vehicles that you can operate a business through. And this could be if you're a restaurant, this could be if you're a consultant, this could be if you're in manufacturing, whatever it is. These are the vehicles you can use. One is called a sole proprietorship. One is called a partnership. One is called a limited partnership. The next is a corporation, and underneath the corporation, there's entities called C Corp, S Corp, or professional corporations. Then lastly is limited liability companies. I'm going to dig a little bit into each of those now. So first is a sole proprietorship. What is a sole proprietorship? This is an individual putting a shingle, as they say, outside their office and running a business. They don't do any formal filings with the state. They don't have a partner or another owner. It's just them, and they don't do any formal filing. And I'll use the example as a consultant. So if you're a consultant, you just put your name outside your door, and that's it. And that is what's called a sole proprietorship. From a tax perspective, the owner's personal taxable income will include whatever is done through that business, through that sole proprietorship. And I should point out, when I talk taxes, and I'll talk taxes here and there on this during this presentation, I'm not an accountant. I'm not a tax attorney. I know a good amount about taxes, but certainly not an expert on that side. So when I talk taxes, I'm giving you sort of the high level. But definitely tax questions, I'll try to answer if you have any, but ultimately I always defer to the accountants because they are the experts on that. But anyway, so back to that. So that's how taxes are reported. It goes on your personal tax return. What's the pros and cons? Well, of this, well, for the pro side, it's very easy. As I said, you don't do anything. You just put the shingle outside and you're up and running. There's no filings with the states. There's no formation documents. What's the downside? The downside is you are personally liable for all debts of the business. So this can be if you do something wrong in whatever your service is, you personally are on the hook and exposed to lawsuits. If there's a contract that you sign, that third party can sue you if there's issues with that contract. If there's an accident of some sort or an injury, for example, somebody slips and falls and sues, they sue you personally. And so all that at the end of the day means you individually, personally are at risk. And more specifically, that means your personal assets. So your personal savings and checking account, your home, all those things are at risk. So while it's very easy to set up, while it's very easy to run the business through, it's almost always not the way you want to go about things. The second level is what we call a partnership. So this is when there is kind of what it sounds like, two or more folks being partners with one another. And this likewise is very simple to get up and running. Basically, it's two or more people merely sharing profits and running a business together. There's no necessarily filings with the state or anything like that. And per the Uniform Partnership Act, and there is an act that governs it, two or more people carrying on as co-owners a business for profit is by definition a partnership. And so that's the way you do it, is you just talk to one another, and that's a partnership. From the pros and cons perspective, it's very similar to a sole proprietorship, meaning from a pro perspective, it's very easy to get up and running. You just talk to one another, and you are by definition of partners and a partnership. On the flip side, like a sole proprietorship, you don't have any type of protection against personal liability. So again, very similar to sole proprietorship, your personal assets are at risk. What happens often when partnership is used, you have what we call a partnership agreement to deal with the basics of the business. As I alluded to a moment ago, there is a partnership act that always is in default and falls back to in terms of the governance of a partnership, but you can have a partnership agreement among partners to deal with the operations, profits, losses, decisions, and all that. And we'll dig into that a lot more in a minute. There's no separate taxpayer ID number, and similar to a sole proprietorship, each of the partners reports their taxable income on their personal tax returns. I will say that for the most part, I always say to clients, there's no reason really at all to be operating a business through either a partnership or sole proprietorship. And now we get to the next level of vehicles that you can run a business through. That is where I would start suggesting. And so the first is what's called a limited partnership. So now to actually form a limited partnership, and kind of like the partnership we just talked about, this is when there are two or more partners in business together. And again, it's not limited in terms of whatever industry you're in. You could be in service, manufacturing, what have you. But here it's two or more partners, and now there is an official filing with the state. It's called a certificate of limited partnership. And in this structure, there are what's called limited partners and general partners. And per the Uniform Limited Partnership Law, and again, in this scenario, there is law, an act, a New Jersey act that governs, called Uniform Limited Partnership Law. It spells out the rights and obligations of each a general and a limited partner. A general partner is the one who runs and manages the business, and a general partner has those same types of personal exposure that a partner has in the partnership. On the other hand, there's limited partners. Limited partners now have personal protection. And this is the key in terms of running a business. Limited partners have personal protection. And under the partnership law, the Uniform Limited Partnership Law, as a limited partner, they would generally not be held personally accountable for the partnership business. Critically, however, in exchange for that protection, they are not allowed to exercise any real management or decision-making authority. That's reserved for the general partner. And so where we find this type of vehicle used is often for real estate investments and estate planning. Very similar to partnerships and sole proprietorships, I typically would not recommend using this vehicle for the general types of businesses that I deal with. Again, that being things like service industry, manufacturing, things like that. I really only see it in estate planning related situations and very limited in real estate investments. So I put all three of these vehicles in the same bucket, which is I would never recommend using any of those vehicles. It's the last two vehicles, corporations and limited liability companies, that I do use all the time, do suggest all the time, and I'm going to talk about more now. So now we have to talk about corporations in limited liability companies. The first concept is protecting your personal assets and minimizing risk to the individuals. A corporation now shields the individual owners from personal liabilities. And if you think about it, we all invest in the stock market. We all have shares of stock in Microsoft or in Google or in Facebook or whatever. We all own shares of stock. While it's slightly different because they're public companies, but it can be sort of carried down to a 2 or 3 or 4 owner corporation. It's the same concept. Those 2 or 3 or 4 owners own shares of stock in that corporation. And just like all of us have no exposure relating to our ownership in Facebook and Microsoft, the whole concept of a corporation and ownership is that that entity shields everybody individually, the individual owners, from liabilities and risks. And so if, getting back to my examples before, a slip and fall in the parking lot, a contract is in breach and a third party sues, who do they sue? They sue the owner of the business. The owner of the business is the corporation, not the individuals. And you have now effectively shielded yourselves as individual owners from the business creditors and the business liabilities. And that's what ultimately you want. And for the most part, you will in fact be shielded from personal exposure. The examples or situations where you wouldn't be shielded is, number one, when you give a personal guarantee. A lot of times in small businesses, a third party knows that a corporation has very little in the way of assets or operating histories, and therefore may want the owners to stand behind contracts. For example, if a business gets a line of credit with a bank and has a line of credit of $500,000, and the borrower technically is the corporation, the bank knows that, hey, this corporation may have very little assets and very little operating history to stand behind. I want the individuals on the hook, and they will have the individuals sign a separate personal guarantee. There are other very specific scenarios like that where you do have personal exposure, for example, taxes and tax withholdings. But I will say again, for the most part, you're shielded from personal liability. The other big exception is what's called piercing the corporate veil, where you do in fact have a corporation that you operate through, but it's really a sham. And the sham comes into place where there's many factors that courts will look at and people will sort of allege, but at the end of the day, they try to what's called pierce the corporate veil by alleging sham based upon certain factors that are in play. Either you don't follow corporate formalities, that that entity is not operated as a true standalone entity, but rather monies are commingled with personal monies, and the individual or individual owners themselves are really acting on behalf of the business, and they don't have a separate business entity. It's a high level or threshold for any creditor to go and what we call pierce, but nonetheless, it's out there. And so as long as you're operating the business as a standalone, separate entity, separate institution, it's very difficult to pierce the veil. So this is the corporate side or corporation side. Drilling down slightly, there's 2 types of corporations, what we call C Corps and S Corps. And these are tax-related terms. C Corps are what's called subject to double taxation, which is when, on a very high level, when earnings are generated, they are taxed at the corporate level. And then when profits are distributed out to the shareholders, they're taxed again. So it's taxed 2 times. An S Corp, on the other hand, is a tax election where you can elect to be taxed once. And it's not taxed when it comes in, when the revenue comes into the corporation, but rather taxed only when the money comes out to the individual owners, and it's taxed once. And if you ask the question, well, why would anybody ever be a C Corp over an S Corp? There are various reasons why that would be the case. There are limitations in the concept or in the contract of who can be an owner of an S Corp. There's limitations on the number of individual owners that you can have. There are limitations in classes of stock, meaning you can't have more than one class of stock. So for many small businesses with 2, 3, 4, 5, 10 owners, an S Corp is the way to go when you operate through a corporation. As you get bigger or on that same level when there are a handful of owners, for tax reasons, you may not want or may not be eligible to even be an S Corp, and you might have to be a C Corp. And again, these are all tax driven. The last entity to talk about is a limited liability company. And as I said a few moments ago, when I talk to clients, I counsel clients and say, don't even consider partnerships, general partnerships, or sole proprietorships. We're only talking about LLCs and corporations. And very similar to a corporation, LLCs are, again, very similar. Number one, from a tax perspective, they can be treated as a single taxed entity, kind of like the S Corp. Number two is it has very similar protections against personal exposure or personal liabilities to the individual owners, and like a corporation. So between those two factors, again, I always stress either be an LLC or a corporation, and then I'll have a conversation with the accountant, with the client, which one it makes sense, because there's certain things that are done in one from a tax perspective that you can't do from the other. And depending on the preferences of the individual owners, that will dictate which one they're going to be. But at the end of the day, both the LLC and the corporation gives you the tax benefits that you want and gives you the personal liability protections that you want. And lastly, just to touch upon it very quickly, if you are a professional, a licensed professional, such as attorneys, physicians, engineers, accountants, anybody who is licensed, depending on your license and your governing licensing body, you may have to operate your business through what's called a professional corporation or professional association. Again, that's dictated a lot of times by the licensing body itself. And so we'll sort of drill down on that if and when that comes up. So that's the concept of the various vehicles that you can operate your business through. Now I'd like to give a quick overview on what the governing documents would call for. And then Jane, I'm trying to look, I don't know, is there any questions before we move on? Actually, I see one here.
Yeah.
What's the vehicle of a company formation to be used by a 401k trust, along with partial funding by individual owners to purchase property, getting fixed income and any loss transferred to the individual owners? I think, I'm not sure if I fully understand that question and whether we're talking about it as a 401k or real estate venture. If we're talking a real estate venture, as I said, a lot of times in the real estate ventures, you'll use an LLC or a general partnership. I personally don't like general partnerships, and I would usually sway to the LLC side of things. And I think for the most part, that's what most accountants would suggest as well. And so, again, but those are the types of questions that we drill down on when we understand, specifically what you're looking for.
Got another question from Sumita. If I have an EIN and New Jersey BRC as a sole proprietor, can I up to an LLC without changing the numbers? I guess the EIN numbers.
Okay, so I think this is an EIN question, and I'm not sure what a BRC is. I'm not sure off the top of my head what that is, but if it's an EIN question and you have an entity, there are ways to preserve that EIN when you switch entity types. Under the New Jersey Corporate and LLC Acts, you can convert from LLCs to corporations and vice versa, or you can merge LLCs into corporations and vice versa. And the taxpayer ID number, depending on how you're structuring it, the surviving entity or the resulting entity could preserve that taxpayer ID number.
She says that the BRC is a business registration certificate.
Okay, so that might be a certificate that is specific to whatever your business or your industry is. And maybe what you're asking is if you have some type of certificate or permit, will changing entity structure or vehicle somehow affect that permit or certificate? And I think it's very specific in terms of whatever specifically that permit or certificate is. Sometimes the answer would be yes, that there might be an issue. Probably more often than not, the answer is probably no, you'll be fine. But again, I think it's very specific in terms of what that certificate actually is.
Melanie is asking, does an LLC allow for a non-alien resident partner?
So I'm sorry, did you say LLC?
Yes.
Yeah, so LLCs are very flexible in terms of who can be owners. I mentioned a moment ago that S Corps have certain restrictions. LLCs, on the other hand, are very flexible. So LLCs can be owned by individuals. LLCs can be owned by foreign individuals. LLCs can be owned by other corporations. LLCs can be owned by other LLCs. So it's very flexible in terms of who can own an LLC.
And then we have one, what documents do we need to obtain an LLC? I am currently a sole proprietor.
So outstanding question there, because that's exactly where I'm going. So that's the perfect question. So I'm talking now of governing documents and how to form those entities, and then what you need as a sort of, again, the governing documents. So number one is formation steps. I kind of alluded to this earlier. Always talk to an accountant. Accountants and attorneys are both important when we're talking in terms of forming and what type of entity, but you definitely should talk to your accountant because tax considerations often dictate which one you want. But in any event, in terms of forming sole proprietorship and general partnerships, as I alluded to earlier, nothing is needed there to form. Limited liability partnerships, you need a certificate of limited partnership, which is filed with the state. And again, all three of those, I would say, is for the most part, we don't touch. Corporations and limited liability companies, they do in fact have a formal filing. So in terms of the question that was just asked, you're a sole proprietorship and you want to either have a corporation or an LLC as your vehicle going forward, you would file with a certificate of incorporation or a certificate of formation, and the guts of them are more or less the same, which is this screen, which is we need to identify, it's a very straightforward, simple certificate that we file with the state. It identifies the name of the entity and the type of the entity. It identifies the purpose of the entity, and you don't necessarily need to say exactly what industry and what you do. You can if you want, but oftentimes, or I should say most of the time, we set up that and state that you can be in any legal venture that's permitted under the applicable act. And you need what's called a registered agent. And every state, including New Jersey, requires a registered agent, which is an address, a person and address where the state can mail information, tax-related information and corporate-related information. And every state requires that, and most states require it to be an address physically in that state. We prepare it. We file that certificate with the appropriate governing department here in New Jersey. It's the Department of Treasury. I do a lot of New York work as well. It's the Secretary of State in New York. And then digging down a little bit further, if depending on your specific industry, sometimes you need to get a different approval within a state agency. For example, in New York, if you are a physician and you want to form a new corporation, you need to both file it with the New York Secretary of State, and you need Department of Education approval in New York. So depending on the state. Once you form, and before I jump into that, the formation process is fairly quick. It takes, one business day at most. If it's slow, maybe 2 business days, but it's a very quick turnaround time. Once you form it, and we can do that with you through our office, you get the taxpayer ID number. So somebody asked about that earlier. That's a filing that's instantaneous on the government's website. You get the taxpayer ID number, also called the EIN or employer identification number. You get that, then you can open your bank account, and then you're really official at that point. You get whatever insurances you need. If you're, we talked about the S corporations earlier. If you're making an S election, you do that at that point. But it's a fairly, these initial steps are fairly quick and not overly complex. Then we get into sort of the governing documents once you are official. I alluded to earlier a partnership agreement when talking about partnerships, and as a general concept, I'm going to use the agreement names partnership agreement, stockholder agreement, and operating agreement kind of interchangeably. These are the documents that sort of govern the entities going forward. I will say number one, and this is when there are multiple owners, by the way. I will say number one, it's not a legal requirement whatsoever that you have any types of stockholder or operating or partnership agreements. These are not legal requirements. If you don't have them, you're not doing anything illegal. You're not violating any law. However, it may not be the best business idea not to have one. It's always a good idea with multiple owners to have these agreements in place. And again, it's not a legal requirement, but it's a great idea from a business perspective. And what is a partnership agreement? What is an operating agreement? What is a stockholder agreement? They're kind of one, they're different documents or titled differently, depending whether it's a partnership or an LLC or a corporation, but the guts of the documents hit the same points. And what I would say, which is the last bullet here, is it outlines the expectations. You would like to know what your deal is with your partner and hope that your partner or partners have the same understandings of your deal. And that's what a partnership agreement does, or operating or stockholder agreement. That's what they do. And it hits a handful of basic points. Number one is who are the owners and what is their ownership percentages? You may think that that's a very obvious question in terms of operating a business, but believe it or not, I've been in many deals where a dispute has arisen a year or 2 years after the business has been up and running, where they argue over who owns what in terms of percentages. So these outline very clearly who the owners are and what the percentages are. It outlines, to the extent you wanted to outline, how a business is managed and operated, and more specifically, who or what are the governing folks, and what are they required to do, and what decisions require what type of vote. So in a very simplistic world, and logic in some respects controls, which is majority controls. If you own 51%, if there's no document that says otherwise, if you own 51% of a business, you control. And that might be fine, depending on the deal, but that's certainly not necessarily the only answer. You can own 1% and control it 100%. You can own 99% and have zero decision-making authority. Again, there's no right or wrong answer. And getting back to something, I said before, which is outlining expectations. It's going in to a deal, hopefully understanding each party's rights in terms of voting and how decisions are made. You don't want to get to a point where you think you understand what the deal is, and you can't do it because there's a fundamental misunderstanding in terms of the structure of voting. And an extension of this is the responsibilities and time commitment from each of the owners. Just because you're an owner in a business does not give you any responsibility to ever do anything, or on the flip side, doesn't give you the right to do anything. So, for example, I once had a set of husbands and wives, 50-50 owners in a restaurant, and they didn't have an agreement. And one husband and wife was at the restaurant every day, working 80 hours a week and running the restaurant. The other husband and wife would show up every few days, sit at the bar, have a few drinks, have dinner, and then leave. And the first couple who was there running the business got very upset over time, saying, hey, they're taking half the profits, but yet they're not doing anything. And it led to a dispute eventually. And point is just because you're a 50% owner doesn't mean you need to dedicate 50% or 100% or any of your time. So in addition to what we've already talked about, identifying who the owners are, what the percentages are, how a decision made, it's the time responsibilities of each party, of each owner. And then lastly is the buy-sell end of everything. Ownership in a business, stock, LLC interests, it's an asset. It's like a car. It's like a pencil. If two of us are owners in a corporation, I can't say to my partner or my co-owner, I don't like what's going on. I want to force you out of here. I'm going to buy you out. Or if that person, my co-owner, passes away, just like the pencil, just like the car, ownership goes to the estate. And a lot of times, folks don't want that. Business owners don't want that. So what a partnership agreement will have is what's called buy-sell provisions, which outlines certain triggers that may force or give an option of a buyout. In a very simplistic example, if there's two owners and one of them passes away, as I mentioned a moment ago, without any type of agreement on point, the estate and the spouses and the kids, or whoever the beneficiaries are of that estate, would get that ownership and become a 50% owner in the business. And a lot of times, folks don't want that as a business. They don't want spouses, they don't want kids, they don't want other beneficiaries involved in the business. And so, in a partnership agreement, you would outline if somebody passes away, the other partner either can or must buy out, and if so, the mechanism for the buyout in terms of how to value it and the payment mechanisms. And again, with this, and I use the example of somebody passing away, but it could be the same thing of somebody quitting, somebody being kicked out, what have you. All these things could be triggers for buy-sell. And so all of this, and in a nutshell, all of this should be thought about early in the relationship. And again, I get back to the word expectation. It's always better at the beginning of the relationship to talk through these points before there's any problems, when everybody is going into that deal with eyes open and with no agendas. If you wait until an issue happens, and when an issue happens, it's almost too late a lot of the time. In an ideal world, you take a partnership agreement, you take a contract, you put it in a drawer, you never look at it again. And the only time to look at it is when there's a problem, and you hope that your problem is addressed in that contract. And without that, if there's a problem, a lot of times you're left to an argument, and worst cases, a lot of times you're left to courts, and you'd rather not be in a court. So that is the overview of what I would call the most material or significant internal governing document.
Peter?
Yep.
We have quite a few questions. Do you want to take a few questions?
Yeah, why don't we take a few seconds and go through a few questions?
Okay. So this is from Jennifer. She says, I have a C Corp, but considering switching to an S or Corp or an LLC, will I need to dissolve the C Corp and restart the new entity from scratch?
No, you will not need to dissolve and start from scratch. However, and it's the same theme over and over and over. However, you need to talk to an accountant. Switching from a C to an S, for example, there are tax ramifications, or I should say could be tax ramifications to that switch. And so before doing so, definitely talk to an accountant. Doing a switch from a C to an S is a tax filing, a tax election, which your accountant can easily do, assuming that once you analyze the tax end of everything, it makes sense. Switching from a C Corp to an LLC, again, talk to your accountant, and then I would be involved with that, because there would need to be filings that need to be done to convert that entity structure from the C Corp to the LLC with the state. But again, the starting point on both is talk to the accountant first, definitely.
Fahad says, I have an LLC registered in New Jersey and business in New York as a foreign entity. Do I have to file taxes in New York, or would be just filing in, or should I just be filing in New Jersey? An LLC registered in New Jersey.
Yep. So the answer is it depends. And again, this is an accounting / level of business that you're doing in New York. There's typically a de minimis level of business that would not require you to file tax returns, but once you pass that particular threshold of business, then you would file tax returns. And it's very, obviously fact specific. So the answer is it depends. And it's something that we certainly could talk about with your accountant if and when the time comes.
Ginger says she has a service business. She's the only employee. After 20 years as an LLC, her accountant is advising changing from an LLC to an S Corp. Can you offer any information from a legal perspective, which one is best and why?
From a legal perspective, I would say it generally speaking doesn't matter. From a legal perspective, they're both going to give you the same personal protection in terms of creditors and creditors going after you. So from a legal perspective, I'll say generally you get the same protection, and that would be my main level of focus on that. And again, unfortunately, I always get back to from the tax perspective and from the accounting perspective. There are reasons why you would do one over the other. For example, in corporations, S Corps, you can be an employee and pay yourself like on payroll, and there'll be employment withholdings. Whereas if you're an owner of an LLC, you wouldn't or couldn't be quote unquote an employee. And so when money comes out, it's without withholdings. And sometimes it's from a tax perspective, which one, and there are other examples like that. And so sometimes the answer is not a legal question, but again, rather an accounting or a financial perspective is of which one makes sense from that side of things.
Okay. From Anu, if you are a single person LLC, do you need an operating agreement and minutes?
So if you are a single person LLC, I will say, while you don't need to have it, it's not a bad idea to have it. And I, for example, have a very, very, very simple template operating agreement that shows that that LLC is owned by one person 100%. So I don't think it's, well, you don't legally need it. I don't think it's bad business to have it, because even when you are a single member LLC, a lot of times third parties ask for the operating agreement. For example, when you open a new bank account, they may ask for it. When you're entering into a contract with if you're in, you do public work, they'll ask for it. So sometimes it's good just to have. And as I alluded to way at the beginning in terms of piercing the corporate veil, the more things you do to act like a real standalone business, the more protection you have from piercing the corporate veil. So to the question, having annual meetings and minutes, yes, it's just by yourself, but have that annual meeting and do minutes again by yourself, and just have it in place, and it gives you that extra layer of protection if some creditor would try to say something.
And doesn't a partnership need to have equal contribution from all partners? Then profits can be divided by further contributions. Is that correct?
So the answer is it depends. It depends on what your deal is. And so I have business ventures where one person is the money person and one person is the worker person. And so the worker person puts in zero money, and the money person puts in all the money, but does zero work. They're an investment, so to speak. There are times where businesses require very little upfront capital contribution. And so while it could be equal, whether it's 2, 3, 4, an equal contribution, it might be very little. Sometimes the answer is straight up no, is that the deal is we're 50-50 owners, and one of the owners will put up the initial capital as a loan. And so long story short, the end answer is it doesn't need to be that way. And that's the importance of having a partnership agreement, because you don't want to have to ask that question 2 years after the fact when your partner didn't put up the money that you thought they were going to be putting it up. You want to know that out of the gate.
Melanie wants to know, are there generally foreign entity corporate filing requirements for LLCs to do business in other states, not tax filings, but corporate formation filings?
Yeah, so obviously it's very state specific, but generally speaking, yes, every state or every state I can think of requires that at least you file an annual report that will certify or set forth your main office and your officers. So and that's not a tax filing, but rather it's but again what they call an annual filing. And so every state has its specific requirements, but that is one that comes to top of mind that most require. And then obviously, if you're in a specific industry, that specific industry may have specific filings that are required. For example, banking. And I can think like the banking boards may require something even beyond that.
Annu wants to know, do you recommend an attorney when applying for a trademark, or can the company just go to the USPTO and fill out the paperwork?
Okay, so let's I just obviously skipped through a bunch of slides because we only have a few more minutes, but let's talk about intellectual property for a second since you're asking that question. So the starting point is I would always recommend having an attorney do a filing for you. I do a little bit of trademark and intellectual property work. One of my partners actually is a specialist in it, and I always ask her to get involved. But I always have or suggest that you don't do the filing by yourself, but rather you have an attorney who specializes in it do it. They'll know the process. They'll know how to do the process most efficiently, and maybe more importantly, they'll know if you have a problem with your hopeful trademark sooner and try to sidestep that or address it earlier on rather than dealing with it way later in the process if you do it by yourself. And you don't want to be in a situation where, for example, if you're potentially using a logo, for example, and you're doing the filing by yourself, and you've dedicated a lot of time, a lot of money, a lot of marketing efforts for months and months and months, only to be rejected many months later. If you come to an attorney, they may be able to tell you right away, hey, we have a problem with this. So I would always suggest you go to an attorney. A few things on that, because I think it's a good point to talk about. first of all, trademarking or intellectual property, it could be done on logos, it could be done on the name itself, it could be done on like your tagline or your lingo, things like that. Or if you have different product lines, you can have trademark the different product lines. So there's many things that you may want to trademark and protect. One thing I do want to point out, a lot of times I have clients that form an entity and think by forming the entity with the state that they then have federal, U.S. Patent trademark protection by filing and by forming the entity and using the entity name. And while there are common law rights, the formation does not in of itself give you a trademark. You need to take that step to actually go trademark. Again, if it's the name of your business you want, trademarking the name of your business. We can go down a whole separate conversation in terms of rights to a mark by using it that may or may not trump others' rights. But again, at the end of the day, and this goes back to what I said a moment ago, I would always say is if it's something that is worth protecting and something you're considering, do it early on in the process and have an attorney get involved.
From a score standpoint, we get this question a lot, and we also, a lot of these things you can do yourself. You can file all, go to the state, you can open your business, you can do all of this stuff yourself.
Right.
But the bottom line is you don't know what you don't know. And that's where people get in trouble. I didn't know that I had to do this. I didn't know that. And that's where your accountants and your lawyers come in, is to help you navigate those waters and protect you further down the line. And then that comes into the biggest question that we usually have is so many small businesses just don't have deep pockets. So where can you go to find an attorney to file your LLCs to help you with your patents that's not going to cost an arm and a leg for a small business?
Yeah, no, Jane, that's a great point. When I get a call from somebody asking to do whatever it is, I need a partnership agreement, I need a trademark, I need to form an entity. I certainly appreciate the question of how much is it going to cost. And so I totally understand that question, and it's a question that you should ask. And the attorney should be able to give an answer in terms of maybe not to the penny, but a general ballpark in terms of what it's going to cost. For example, if you called me up and said we want to do a partnership agreement, I could walk you through the process, or I would walk you through the process in terms of from that first phone call to actually signing the document, what the process is, and then potentially what the cost would be. And same thing on, again, any task. I skipped over slides just because we're bumping up against 11 o'clock. I skipped over a discussion I was going to have on, giving an overview on leases and employment agreements, but it's the same thing. If a client says to me, hey, I need a lease reviewed, I'd say, okay, here's the process, and here's what you could expect the legal fee to be.
I think the other place you could go, and certainly Peter's firm can do all of this, but the other place you can go, I believe, is to your state or your county bar association. Most of them have websites, and you might find a referral to an attorney through the bar association at the county or state level, and just call some, if you see 2 or 3 attorneys that specialize in patent or, filings or so forth, give those offices a call and find out what they do charge for it. And
and Jane, to even add to that, I've said accountant a million times during this presentation. I work with accountants on a daily basis, different accountants all the time, and so I'll have clients that ask me, "Hey, I need an accountant," and I can give them a name of somebody I'm very comfortable with, and I'm it's the same on the flip side. Is accountants always say, "Hey, call Pete up if you need something." So talk to the folks you already know and trust, your advisors, your accountant, or whomever. They also probably have relationships with people they really,
That's
really like.
a good point. And we have one more, and I think we're going to have to wrap it up. But Ginger said, my accountant said she would file the S Corp docs. Should I also consult an attorney?
So again, if we're only talking filing an S election, your account, it's a tax question or a tax issue, and your accountant definitely would be the one to tell you one way or the other on it. If we're talking about, again, going from an LLC to a corp or a corp to an LLC, that's when I would jump in. But if it's strictly saying, hey, I'm a C corp, should I file an S corp or elect S corp election? That's an accounting question, and definitely, step one is talk to your accountant.
And well, I guess I'll do one quick one. Is a DBA transferable, especially when selling a business?
Yes. Yeah. So DBAs, what's called doing business as, or a certificate of assumed name. You operate a business, like for Google is the perfect example. Google is Alphabet. That's the legal name, but everybody knows them as Google. That's a DBA, doing business as, and that's a filing you do with states. And yes, they are transferable.
Okay, Peter, this was great. Thank you so much for your time and all the good information that you shared with us. We would love to have you contact us at centraljersey.score.org. If you'd like to get a mentor, your mentors can help you work through all of this stuff as well. And contact us. We'd like to help. Everybody have a wonderful day. And join us again at our upcoming webinars. You'll be getting information about this webinar and Peter's slides in a day or so.
Thank you, everybody.
Thanks, Peter. We really appreciate it.
Jane.
Bye.
Bye-bye.
Take it away.